Happy New Year, everyone, and welcome to episode 8 and the first of 2025 on The Global Lawyer, the São Paulo Lawyers Institute's podcast that brings together brilliant legal minds from around the world. And I couldn't think of a better way to kick off the year than with today's incredible guest, Debra Dandeneau, the former chair of Global Restructuring and Insolvency until 2022, if I'm not mistaken, at the prestigious Baker McKenzie in New York, the first woman in that position. Debra will take us on a journey through her extraordinary career, sharing insights from her experience in the fascinating world of restructuring and insolvency law. So, get ready for an inspiring and thought provoking conversation to set the tone for an exciting year ahead. Debra, thank you so much for being with us. It's a tremendous pleasure to have you here. Thank you so much.
Thank you, Marina. Happy New Year. And it's really my pleasure. Really happy to be talking with you today.
Great. So, to start, could you share with us your journey as an insolvency and restructuring lawyer at a prestigious law firm like Baker McKenzie, and what led you to this point in your remarkable career path? And also tell us a bit about your legal education along the way and
Oh,
what were the factors that influenced your choices.
okay. Uh, that's a lot. Uh,
Yeah, yeah.
I
You
will
can
start by
segment.
saying I did not start at Baker McKenzie.
Hmm.
I was fortunate to start at a firm and spend 30 years at a firm called Weil Gotshal and Manges.
Oh.
And in those days, when I joined, uh, it was a group of people, partners all the way down, who were so passionate about restructuring law. And the firm did a lot of other things, but the restructuring practice was considered the preeminent practice in the group. And you could not help but think that you could get in a room and anybody could raise any question and everybody would have a point of view on it. It was focused on being very intellectual, but also commercial. So, as a young lawyer, being
Mm.
immersed in that process was just fantastic. And that passion really, it can't help but rub off on people. And I remember, just in terms of standards of excellence, one time somebody asked me, "Oh, was this brief ready to be filed?" And I made a maybe a snarky comment at the time saying, "Well, it's good enough for this court." And the partner said to me, "Is it good enough to put our name on it?" And I've never forgotten that. And
Wow.
that's
That's
that's always been the
wild.
standard that I've tried
Wow.
to adhere to. So I think that that's how it was a great start for me to have that. I would say I think the restructuring law practice has changed a lot. I think that the
Mm-hmm.
current model that a lot of the kind of very successful firms are using is more along the lines of let's bring in the client and then we'll focus on the next one and we'll use our playbook and we won't have this bespoke intellectual commercial approach to matters. But when I joined, I said 30 years at Weil. And then I got a call, was not very happy there, was not looking to leave, but somebody talked about Baker McKenzie
Mm.
and the opportunity to lead the global practice and form the global practice and really
Wow.
connect the dots made me think I can take everything that I learned in throughout my really amazing time at Weil, bring it over to Baker McKenzie and really bring that philosophy and that practice
Right.
to Baker McKenzie.
Mm-hmm. Wow, that's fantastic. Your story is truly inspiring. And it's a great reminder of how passion combined with strategic decisions such as that one can carve such a unique path. And
Yes. Yeah.
and now, given Baker McKenzie's global footprint, do you find that cross-border bankruptcy cases or restructuring and insolvency cases pose unique challenges compared to domestic ones? Yes, and particularly in terms of ensuring consistency and collaboration across jurisdictions. Do you think international legal frameworks for insolvency and bankruptcy are evolving at the pace required to address the needs of multinational companies? Oh, what changes would you advocate for?
Okay. Well, first of all, it's interesting because when we talk about cross-border restructuring, it's I have the same reaction that I have when I meet young law students and they say I want to do cross-border transactional work, and I'm like, do you really know what that means? Because cross-border restructuring can mean, on the one hand, we have multiple cases going on in different jurisdictions, but
Mm-hmm.
but increasingly it can mean we're going to some place that can be a one-stop shop.
Mm.
And in the United States has really marketed itself as it has a very it's a big tent when it comes to restructuring. It's a very low bar for companies filing. And if you think of even like
Mm-hmm.
Golinius commenced its Chapter 11 case. It did not commence a case in Brazil and then seek recognition in the United States. It can handle everything in the United States. So
Yes.
what's been interesting is over the time that I've been at Baker, it's really been a period of time where other jurisdictions have been reforming their restructuring laws to adopt elements of the US model. And what's really fun about what I've done at Baker is say, okay, and this is going back to best practices.
Yeah.
This is how it works in the US. And for example, when Singapore wants to be a one-stop shop in Asia because
Mm-hmm.
they are the focus of a lot of the commercial relationships in Asia. So Singapore adopted very a system very much like US Chapter 11, and every law firm was going out there giving speeches on, oh, let's talk about the new law.
Uh-huh.
I came out there and spoke, and I said, okay, but let me tell you how it works in practice. You
Mm.
use these terms, but this is how it works. And people came up and said, this is the first firm that's talked about how it works in practice.
Wow.
And so it's been a lot of fun to take those concepts of US and say, how are we going to work in practice? Involved in out of court restructuring Saudi Arabia. Again, similar concepts. Never
Mm-hmm.
really had done it before, no reported decisions. So bringing
Wow.
that experience, done the same thing in Japan.
Wow.
So bringing that experience to these different jurisdictions, first you have to understand what the law is in that jurisdiction,
Yes.
what the
Yes. That's.
limitations are,
Mm-hmm.
and then understand, okay, within this framework. So that's a lot of fun too. Within that framework, how can we take some practices that we've used in the US
Mm-hmm.
and if we're going to do a restructuring in that country and do it there? And then alternatively, is it possible to go to a one-stop shop
Right.
and use go to US or something and consider whether that's an option. So we're always thinking about, and there are a lot of factors. For example, what are the problems? Are we doing a balance sheet restructuring? Are we just dealing with, if we're just dealing with financial creditors, that might point us in one direction. If we have to deal with local creditors and local
Yes.
contracts,
It's
well, we
different.
may need, it's different because we don't want a very elaborate, sophisticated restructuring plan to go awry because the local creditor has decided to run to court in some jurisdiction. So
Mm-hmm.
all of that you this is the 30-second view of you all of the things you take into account.
Yes.
You think about all of those issues when trying to decide what are the problems. Whenever I come to the first question I ask a company is, what do you want to achieve? If I had a magic wand, right? And
Yes. What's your goal? Where
which
do we want to
PS
be?
I don't, but if I had a magic wand and I could do anything, what would it look like? And how are you going to come out? And I think that's the biggest
This is
problem.
key. This is key.
Yes.
You have to ask this question
Right,
beforehand.
because if you don't know what you want to achieve, you're
It's
just going to be wandering down this path and not even knowing if it's the right path.
That's so true. Yes, and here in Brazil, we have, as you know, we have borrowed from the U.S. Chapter 11 example, and we are discussing here recently because it was our bankruptcy or restructuring or judicial reorganization law was reformed. There was a huge overhaul in 2020. And the introduction of, for instance, the deep finance. The deep finance is a huge
Right.
piece of news for us. And for the company, it's like it brought some life to the going concern, as a going concern, right? And also the creditors plan, when the debtors plan, the debtors restructuring plan is not approved, then the creditors sometimes, depending on the circumstances, the creditors can come up with a restructuring plan uh, uh, designed by them. So it gives a much more leverage to the creditors, and it is different from what we had before, where creditors they're no longer backed into a corner. So this is now where debtors would say, "This is our plan, so take it or leave it." This is
I,
no longer the case.
I think it's interesting because we have those two concepts in the US, including the right of creditors after a certain period of time to propose a plan. But let me talk about dip financing,
Mm-hmm.
because a lot of people, when they talk about having the right to have dip financing, which I agree is so important uh, to a restructuring effort, they talk about the ability to what they call prime the existing liens, to put on super senior debt.
Yeah,
The
super
funny
senior debt. Mm-hmm.
the funny thing about that, it's the same thing with cram down, right? Which is funny
Mm-hmm.
because everybody loves that, and the same word gets used no matter what jurisdiction. That's like, I think, the favorite term in restructuring. But but dip financing and priming rarely happens on a non-consensual basis. Almost always, it's your
Mm.
existing lenders, or at least a subset of the existing lenders, who are agreeing to essentially prime themselves. And so
I
everybody
see.
thought this priming is this amazing tool. And in
That you
certain
can show.
circumstances, it can be, but
Uh-huh.
it rarely is, because we still have standards. You still have to prove that if you are priming an existing secured creditor, that their interests are adequately protected. And it's
Right.
very difficult to do. So that's why we often, almost always, again, there are exceptions, almost
Right.
always our priming dips are consensual. So I think
Mm-hmm.
it's a valuable tool, but sometimes some of the elements of it are a little overstated. In terms of
Yes.
creditors' plans,
Mm.
it's interesting because I've been involved in situations where we've had creditors file plans. I've done it and I think that in a very large, the real issue is it happens,
Mm-hmm.
but it is not frequent. It is not customary,
Oh.
because particularly in a complicated case with
Uh-huh.
so many moving parts, it is very difficult, unless again you're trying to achieve a balance sheet restructuring. You don't have to deal with operational issues. It's a smaller case. And I will digress for a second to say we had a case where we represented a creditor. It was
Uh-huh.
a small bankrupt. It was a single asset real estate case. The debtor filed right before they were about to foreclose, and
Mm.
then we said, this is fantastic, because we will now use that opportunity to basically propose our own plan and use the bankruptcy
Mm-hmm.
process for our benefit, to the point where the debtor was trying to do everything then to get the case dismissed. And we were like, whoa, we're very comfortable here. And but that is unusual. That is, I think, an
Okay.
unusual situation.
So this is not yes, this is not how it works on a regular basis. Now, okay, so this, yes, because creditors, yeah, but here in Brazil, it's something. I see your point, and I would also add that it's not enough to have new rules or know to. It's not enough
Right.
to know the new rules, but you must um, know how to apply them and know and anticipate, or at least try to imagine how these rules will be applied, what would be put in practice, and make strategic choices uh, having this in mind. And this is perhaps this is why TAM, the TAM, the airlines, they decided to file for bankruptcy because in 2020 the our law here in Brazil, the reform was already in place, but they decided to file for bankruptcy in using the Chapter 11 in the US.
Right.
Why? Because they didn't know how things would be interpreted here. It was at the very beginning of the law. So it emphasizes what you are saying, because you have to test the model
Yes.
first.
I think it's more than just testing the model even. And I just published a paper through Insol that talks about this very topic
No, you
because
have to share that with us.
I
Please.
certainly
Again, I'm
will.
going to, yeah.
It is it because it's not enough to put, well, it's a good step to to change the laws on paper. But
Mm-hmm.
what you also have to do is you have to now inspire confidence
Yes.
in the companies, in the creditors who often will have a very big input into, especially if I'm going to give you more money, I want to
Mm-hmm.
make sure it's a process that instills confidence. And so how do you do that, even if you've changed the laws on paper? And I think,
Mm-hmm.
again, if we look at Singapore, it's a great example.
Right.
Singapore basically changed their laws, and then they said, okay, and we are going to have special training. We're going to have specialized judges, and we are going to have specialized training, and we're going to actually bring retired bankruptcy judges from the US and other parts of the world here to
Mm.
serve as judges on our courts. So they
Ah,
focused on, because that is where it starts, is with a qualified judiciary.
yes,
And with knowing
no
that the
doubt.
laws are going to be enforced and that you're going to get rulings quickly. And
Mm-hmm.
also in the US, we have such transparency in our cases. Any pleading that's filed, you can access, unless it's specifically filed under seal, you can access online. Anybody can access online. There are still
That's
places in
great.
the world, such as Japan, where if you are a creditor, you may be able to go to the court and ask the clerk to give you a copy of the pleading, and then you can review it sitting there, assuming that the judge does not have the pleading in their chambers. So I think all
Wow.
of these things foster, and then and the other area, which is a whole other topic of discussion,
Mm-hmm.
is the ability to trade debt.
Yeah.
Because the other, what we see is the US has a very well developed market for
Mm-hmm.
trading bank debt. And when you get into that situation, you need entities, commercially driven, experienced entities who are willing to take risks, who are willing to put more money in, and and yes, they are driven by economic purpose,
Mm-hmm.
but but they're willing to take equity. They're willing to be much more creative. And by and large, we think that is also, it's an underappreciated
Right.
facet of what drives a commercial uh, restructuring that at the in the end works. Because if you don't have, often you will have institutional banks, and again, that's changing a little bit,
Mm-hmm.
who are very, they have capital requirements, they're very set in their ways,
Mm-hmm.
much more difficult to deal with them. Again, it's changing at the banks, but
Right.
having the ability to basically create that, I think that is so important, is having a path to trading debt so that the investors who want to come in and take those risks and come up with creative solutions can come into the picture.
That's very interesting. Yeah, here in Brazil, we should. Okay, our system is different, and we have way less banks as you guys do there. But it also seems to be inspiring, and this leads me to my next question, because I would say that this restructuring strategies and restructuring law, it is deeply influenced by economic cycles and financial trends. And from your vantage point, how have you how would you say that recent global economic shifts, such as post-pandemic recoveries and inflationary pressures, they have impacted bankruptcy filings and restructuring movements and strategies? Tell us about it.
Well, I will just let me start by saying I've been through a number of economic cycles. And I think that it helps to have gone through them because
Mm.
it seems that every so often somebody will say, well, everything's going so well, it's never going to happen again. And
Yeah, no, no, no.
would that we're so lucky. And I'm just before I even talk about post pandemic, in 2008, I remember right before Lehman, before everything,
Mm-hmm.
we were having those kinds of discussions at my old firm. Like, well, maybe restructuring is going away. And then Lehman Brothers
Mm.
happened. And
Ah.
and and the housing crisis happened
Mm-hmm.
in the US.
And then,
So the one thing we know is that there will be a readjustment. And what's interesting, when the pandemic happened, everybody thought that was going to be the crisis. But there was so
mm-hmm.
much money that was pumped into the system
Yes.
that everybody rode through the pandemic pretty well with the government support. Now we're seeing the government support being taken away.
Yeah.
And we have a high inflation, so we have high interest
Yeah.
rates. And
Mm-hmm.
companies that took on a lot of this, and again, not a new story, but
Okay.
companies that took on a lot of debt,
Yeah.
they are less flexible, less able to ride out change. And my view is,
Mm.
how do we know, how could we predict, which we can't,
Yeah.
whether a company is going to be able to survive a change in circumstances? Because what a crisis is always something happens that is contrary to your expectations. Okay, it could be fraud, it could
It,
be your market disappears,
mm-hmm.
it could be a lot of things. but
And
but the
today's with things
right,
happening so
right,
fast.
with things happening. So the real question when we look at companies is, how well positioned are they, how nimble are they? And if
Mm.
you've taken on a lot of debt and you're bound to your your high debt payments, if you don't have a robust decision making
Mm-hmm.
structure, you don't have good governance, you have a mindset where, what we call founder syndrome, where you just listen to the CEO and everybody on the board says, okay, yes, we agree. There are so many factors that go into having a good, healthy company, that 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 is, to me, where we need to focus, because it's
Um,
really, how do you deal with unexpected change,
yes.
unanticipated change?
You have
And
to be
again, yes,
prepared,
you have, right.
as much prepared as possible.
And that was a roundabout way. I'm not sure I answered your question,
Yes, yeah, yeah.
but but I think that
You did.
we look at industries and they were affected. So they're affected by some circumstance,
Uh-huh.
and then they have to adapt. And how adaptable can they be? Often we're seeing more and more, because it's just piled on debt with balance sheet difficulties. We're often
Mm-hmm.
seeing those get handled out of court. The creditors come in, they negotiate a balance sheet restructuring, they don't really affect their trade debt, and the company moves on. But even at that, we sometimes see those happen pretty quickly, and then they're back again in a couple of years, because it was a band-aid. But
Um,
I think the
yes.
real in-court processes are for, either you get to a point where, I always say, it's like you need the parent to solve the problems.
Yeah, yeah. Okay.
You need the bankruptcy court to make decisions,
Okay.
or you're using it or you're using it strategically, because
Right.
you have lower voting thresholds.
Yes.
You want to accomplish, going back to what we first discussed, specific objectives. So it's
Uh-huh.
either, in my view, a last resort, or a strategic alternative, a formal restructuring process, but it's expensive. And
Yeah.
that's why it really has to be used in a very specific, targeted way and know why you're using it.
Yes. So in the end, we should say we could say that of course agreeing with the other party and meeting the meeting the interests in a middle ground would be the best. It's the best scenario. It's the best case scenario. Meeting the interests in the middle.
That assumes that everybody is acting in an economically rational way, which is
Yes.
not always
Okay.
the case.
The economic. Yes. 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 And speaking of that, since all of that involves balancing the interests of creditors, debtors, and other stakeholders, what strategies have you found most effective in achieving fair outcomes for all parties involved from your experience?
Okay. And just so to set the stage, I've done company side work. I represent creditors. I've pretty much represented, you name it, everyone in the capital structure.
Oh,
But
that's
I have
awesome.
but
Yes.
I have the same approach, which
Uh,
is and especially from on company side, which is the most important thing is and this maybe is stating the obvious,
hmm,
transparency and building confidence, because when you get to this point, something has gone wrong. Again,
yeah.
something has happened contrary to everyone's expectations,
Yes.
and often we'll find companies can be very defensive, and their
Mm,
first reaction is to kind of close the door.
mhm.
If you're stepping in as advisor to the company, now you have to go to your creditors, and we're rebuilding confidence. We have to basically say we're in this together. And I think
Mm.
at the end of the day, that's the most important. Maybe that sounds a little Pollyanna. I don't know what the
No,
how
no,
that
but it's the
translates.
human
Yeah.
aspect behind all that.
Yes.
It's the
Yes.
human part. It plays a major role.
Right. And we can all run the numbers. We can all see what makes sense. But at the end of the day, there has to be a dialogue, there has to be communication, there has to be recognition. I was involved in a case last year where we were kind of in the middle, and there was a lender and a borrower, and they weren't talking to each other, and they would for I think for 6 months before we got involved, the lender would send a note saying you're in default, the borrower would send a letter back saying no, I'm not, and that was the extent of their communication.
Oh
And I
my.
got in there, I thought, well, now I'm going
That-
to just solve world peace too after I finish with that, because I got in there and I said to the lender, okay, what does the alternative look like for you? Let's walk through your best case scenario. Then I went to the
Mhm.
borrower, what does the alternative look like for
Oh
you?
my.
This is your best
Yes.
case scenario. And got them talking and got a deal. So to me, it may
Wow.
sound really simple,
It's
but
communication. This is basic
yes,
communication. My God. Wow. Yes, it's yes, sometimes people are not interested, are not willing to communicate. They are not willing. They just want the solution to they just want the solution
right.
to be on their lap, and
But we
that's
also
it.
have to recognize that there are a lot of people the people who are handling are people. So there are often a lot of emotions. Lenders could be angry,
Yes,
creditors can feel
yes,
that
that's
you
right.
misled them. The
Again, the
company,
human aspect.
yeah, the company is scared. Hope with any luck, the people at the company have never gone through this before. So is your job as an advisor is,
Mm,
no matter who you're representing, is to make sure that your client can sleep at night and that they can do what they do and you take care of the rest.
yes, that's that's the advice, the
Yeah.
most important advice. Now, talking about high stakes cases, is there any particular case or experience early in your career that significantly shaped your perspective on this field? And what are some of the unique challenges that you faced managing high profile cases in such a competitive legal market? Because it is. And how have you dealt with them?
Well, I'm gonna start with my first case,
Okay.
and then because every single case I don't care how experienced you are, you learn something and you take something away from it. And I remember my first case was a very complicated real estate restructuring with an individual who owned some luxury hotels in his own name and had
Mm.
engaged in a very
In his own
complicated
name, not company?
in his own name,
Oh
yes.
my.
And had engaged, so it was a strangely an individual restructuring. There were some corporations, but also very complicated tax sale, buyback, and all that stuff. So we
Okay.
had to, we had, we checked, we, so we represented the individual. And I just remember what was great about what for me as a very young lawyer was I got thrown into this process. And the very first thing my first job was talking to all the vendor. I learned everything about the hotel industry. It was so much fun. But
Wow.
but I had to talk to every vendor, and I became every vendor's best friend, because
Oh,
it's
that's
like
oh, that's
that
great.
was my job as a young associate. But then getting involved in a very complicated litigation, and
Mm.
then that lasted forever. And I remember I was just becoming a second year lawyer, and we were having this complicated argument on evidentiary objections or something. I had
Mm-hmm.
been in court the whole time, supporting everything. And one of the partners said to me, okay, you should argue this. And I actually said, well, or I think he said, do you want to argue this? And I think my first response was no.
No.
Uh, uh,
Oh
and
my.
and and then he came back, and then I came back and I said, this is very complicated. It's very important, and I don't know if the client and the partner said to me, I have every confidence in you. And by the way, if you talk to this person today, I'm sure he would tell you that story too, because he takes full responsibility for this my success. And I will
Wow.
say what that and so many other cases, what I took away is it's so important to be surrounded by people sometimes who have more confidence in you than you have in yourself, and who will push you to
Mm-hmm.
do things that are outside your comfort zone. If you're that kind of person who enjoys doing things outside your comfort zone, that's fantastic, because restructuring is definitely for you. I now say I embrace chaos. Uh, but 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 I will say that there's
Oh.
another case that for me was a really defining case. I was a
Uh-huh.
again, this was back in the 2008, 2009,
Mm-hmm.
and it was a case that had $1 billion of debt by today's standards. I guess that's not much.
But
Three owners, and it was a real estate land development company. The owners could not agree on anything. They went into bankruptcy, and the lenders were super aggressive. The lenders were super aggressive. And by the way, at that time, nobody was buying land to develop for homes or anything like that, because there was a housing crisis going on.
mm-hmm. Mm-hmm. Mm-hmm.
And because the management was fairly dysfunctional, I had to step in, essentially become general counsel. I was actually the spokesperson. I would every hearing I would know that I would have to give a quote to the media about the case. So I learned how to
No.
do
Oh.
that. I think I was interviewed by Home Builder magazine too. I mean,
Wow.
I and really just learned the whole everything that was problematic with the company at a time when the lenders were pushing to liquidate. And this is actually a case where there was we had agreed that if the owners could not agree on a plan by a certain date, the lenders could file their own plan.
Mm-hmm.
So the lenders, so it didn't happen, couldn't agree. The lenders came in, filed their own plan, which provided for the liquidation of the company. It would have
Oh.
destroyed the company because, by the
Uh-huh.
way, nobody was buying land
The
at that time.
land at that time. Uh-huh.
So I came in and fought for the company,
Wow.
for the
Wow.
employees, for the company, to convince, and this goes to communication, to convince the lenders that this was not the right strategy. And ultimately got to a place where we confirmed a plan. The lenders ended up investing in the company, acquiring the
Wow.
equity. The
Oh
company is still
my.
alive today and
Oh my
doing well.
God. That's
So for
wow.
me, it was a real pivotal moment, because there
Yes.
were very many difficult conversations, and at the end, the lenders actually, even though it was their plan, they actually said to me, "You need to be at the hearing because because you're the one who's going to be able to
You
convince the judge
yes,
to
yes, yes,
to get
yes.
this
That's
done."
right.
So it was an emotional roller coaster because you didn't know from day to day whether you were going to be able to save this company.
Wow.
But I do think that that was a real defining moment for me, and a very
Wow, that's a
challenging case.
fun, that's fantastic. That's wow, it's a pivotal experience, just like you said. And it's yes, and because it is such a competitive market, and so these lessons that you learned, they are worth their weight in gold because now you can use them, and you can it, no one is going to take it away from you. So it's I love that story. It's so nice and very and really inspiring. And were really brave. I'm yes, it's
I, I'm still friends with the people who worked at that company now. We still
unbelievable.
talk. I mean, they hope they never
That's
have to call me again.
that's
But
so nice. Ah, that's fantastic. Now, now we are going to change gears a bit. Let's talk a little bit about the rise of ESG in corporate governance. How do you see these factors influencing the proceedings, restructuring, even bankruptcy proceedings, especially when companies fail to meet sustainability or governance standards?
well, I think that in the let me address this from the U.S. perspective because
Right.
unfortunately we're seeing a reduced focus on ESG
Oh,
in the U.S.
in the US.
And
Ah, yes, I
and
see that.
DE and I and those issues. So
Yes.
it remains to be seen how that's going to get addressed in the future.
Mm.
I, if somebody had to point to one factor, it's governance.
Right.
In the U.S., it's well, I would say ostensible governance because what we have in the US, we have in particularly in the restructuring context is this idea of bringing in an independent director when we have particularly we have a private equity company and a portfolio company and bringing in somebody and we have a whole market for
Mm-hmm.
bringing in supposedly independent directors and that's kind of the extent of and then of course we also have the we have standards for how you make decisions and everybody goes in and every advisor gives the same spiel about
Uh-huh.
what the standards are for making decisions. We've actually tried to develop very specific questions that boards should ask,
Mm-hmm.
that board members should ask, not just give you the little presentation which is the same PowerPoint that every single firm has.
Yeah, got it.
uh, but because you really need to help guide directors in terms of it's not just okay, here are your duties. Okay, I hear that. What do I need to ask? What should
Mm.
I be thinking about? How do I think about that? That's really how we approach it. So
Mm-hmm.
and the other part is everybody is concerned in the US about getting sued. So and so that drives and it's a very difficult it's a very difficult issue because on the one hand we have D&O insurance, we have I think in the US a very robust protect we have very robust protections and they don't exist in other countries.
Yes.
And so what happens is you often have directors acting in an extremely risk averse way. Because unless you give sufficient protection to directors, they are they're going to act in a way that makes sure they don't get sued and totally understand that. Remember, we're all people and nobody wants to get sued.
Yes.
So I think from a governance perspective, I think that's what people talk about. What I really would love to focus on in the
Mm,
future
mm,
is companies coming out of bankruptcy. We have a provision in the US bankruptcy code that is almost never invoked.
mm.
And that says that the bankruptcy court has to review the management structure coming out of bankruptcy and make sure it's consistent with public policy. It's a
Oh,
very wishy-washy
mm,
standard.
okay.
But if we look at companies coming out of bankruptcy, I'm certainly curious about are they really a diverse, are they, do they have diverse boards? Are they putting in
Mm-mm-mm.
place the kind of governance coming out that's going to
Yeah.
help them succeed? And by and large, we see almost all litigation trustees are men. The boards are almost exclusively, I don't want to say exclusively, almost
But
all men. We are
almost all.
not achieving diversity objectives, and
Yes.
and which I think most scholars would agree are part of good governance is having a diverse board. But when a company goes in and out, nobody's focused on that. So that's something I would like to see going forward.
Yes, let's hope for. Yeah, it's. I think it's a trend. Okay, so we have the extremes and sometimes the balance tips for here and there, but I think we still have to be hopeful because I think it's slowly but surely we will get there.
I think though it's a different standard for public companies versus
Yes.
privately held companies.
Uh-huh.
And I
Yes,
don't
because
know
of
how
the
much
yeah.
they're thinking about that.
Mm. Yes, because yes, and here we have yeah, that's yeah, that is an important factor, the public versus private. Uh,
And
yeah,
nobody and you're and even I've seen big cases. Bankruptcy court is supposed to make a finding in the order approving the chapter 11 plan. I've seen big cases they don't even make the finding. That's required by the bankruptcy code because
yes.
people forget about this. And it's just something that if in the back of my mind I want to start compiling those statistics to see
Uh-huh.
what happens really.
Yes. Yes, but I think we are yeah, I okay, I would like to believe that we are in on this path. And this which leads to my next question precisely about the male dominated area of the law. And as a woman leading until 2022 this area in your law firm, have you encountered any specific challenges and how have you worked to foster inclusivity within your team and the broader legal community?
Well, let's just say that over the course of my career, I've received a lot of unsolicited advice
Yeah.
as a woman, and the kinds of things that I would think nobody would ever
Oh my.
say these days, and including uh, uh, being told that my shoes were not professional, or that
My God.
I should have voice lessons because my voice was too high.
Oh no,
Uh,
no, you don't, no, don't, no, no, no,
Yes.
no.
So it's, and also realizing I think we've made a lot of strides. At the end of
Hmm.
the day, and this, I think also it's important that there's a whole generation of women leaders now who have sons who are now
Yes, they do, and they
working,
thank God
and
they have sons, and
right, and
they
they
are
are well trained.
yes.
I think about my kids, but I it's I think what's hard is you still have to. I approached it rightly or wrongly as I have to be the smartest and the most informed and the most prepared person when I walk into a courtroom, when I walk into a room. And by the way, that's not enough
That's not enough.
because you have to, that's your baseline. And then you go from that baseline to now, how am I going to interact with people? How are people going to take me seriously? Or, by the way, when I was a young associate litigating, I loved it when people underestimated me in a deposition. I could get
Yes,
so
because
much
you're
out of I could get so much out of these people in a deposition. Oh, please, I don't understand. Tell me more. But but
That's so
it's always the standard of how you're going to be persuasive. It's
mm-hmm.
different. It's different, and as you become more experienced and you have your brand, obviously people are going to pay more attention.
Of course.
But there's still a club out there. And when you talk about business development, uh, bringing cases, it's again, I came up in a system where everybody, the whole advice was, I had little kids, and the whole advice was you should be out drinking every night with with everybody. And I thought, I don't want to do that. So
Mhm.
I think that you have to find a way that works for you, and you have to find your gravitas and balance it with I believe, with a sense of humor. And
Yes, and take it lightly. And the more women are there in this position, so you have to be we have to be numerals. We have to be
yes,
because the more we are, we can. It's the environment will be automatically more friendly,
right.
and we will have more room and more say. And
And
yeah,
I specifically, and I've done this, well, I was fortunate because when I started
mm-hmm.
at Weil at the time,
Uh-huh.
there were a lot of senior women, and you could
Wow.
not have a case that was staffed, a major case, without having at least two women on that case. So I
Mm.
had a pretty warped perspective, and then we'd go into a room. I'd go with my woman partner, and we'd go into a room full of people, and there'd be all men, and I'm like, wow, it is different out there. Uh, but I have always made it a point of trying to staff my cases with women.
Yes.
Also, when talking to recruiters
Mm-hmm.
who, because I don't think women put, I know from my own experience, I don't think
Yeah.
women put themselves into the market as much as men do. So talking about recruiters saying, you need to bring me women, you need to find them, you need to bring
Because
me
they are
women.
out there.
They
There
are
are
out there.
so many.
Yes.
Uh,
And when I was running our global practice at Baker
mm-hmm.
McKenzie, a majority of our global steering committee were
Ah,
comprised of
that's
women from
fantastic.
around the world, because my that is I have an open door policy for everybody, not just
Mm.
women. And that
Uh-huh.
includes people that I've worked with at my old firm, anybody, even when people left, I would say, you can always come to me for help. If I run into women, even in another firm,
Mm-hmm.
and you have a question, they can reach out to me. I will
Oh,
always make
that's
myself available. That is part of my responsibility.
yes, but that's okay. But okay, that's not the rule, I would say, because you are very special, Deborah. I have to say that because okay, it's a very a highly competitive environment, and that's wow, that's wonderful to know that. And I was about to ask you about your mentoring activity then and I can see that you have done that already because in addition to your impressive legal practice, I can see that you mentored many young lawyers. And how do you approach mentorship? And now, at this point, what advice would you most often share with those entering in the field, in this particular field?
Well, this is a difficult field. And I'm
Mm,
going to now back up and say something else.
okay.
Like, when I was a partner at Weil, there was an article that came out in the Wall Street Journal. I think it was a
Mm,
letter from a partner at some other firm.
mm.
And basically, it was about why women can't be successful restructuring lawyers. So, and
Oh my
trust
God.
me, there are people of an age who remember this. So I went to we had 5, 6 women partners in our group.
Uh-huh.
And I said, we need to do something to respond to this. We wrote a response. We were a
Oh,
picture
you
taken by
did.
the Wall Street Journal. To this day, people come up to me, even if they've never met me, and they said, I remember that because it
Wow.
was important. Because you know what? It's a hard job. The
Yes.
being working in law is hard.
Yes, I would say
It's
that not this field, okay, but law in general.
But there are also a lot of other professions where people have to work really hard.
Mm-hmm.
And I will say my mother was not a professional. She had to work 3 jobs, non-glamorous jobs, to make ends meet.
Uh-huh.
So what I say to people is you have to work hard and you have to make decisions. And
Mm-hmm.
you're not going to have everything. I don't believe that you're going some things going go, at any given time, something's going to give. And with any luck, you'll
Yes.
have a supportive environment. You'll have somebody who believes in your success, as my family has always championed my success,
Oh, that's
and that
invaluable.
you'll just maintain your sense of, I think nowadays especially, I love the focus on wellness.
Wow.
You will maintain your focus on wellness. So that's what I'm saying. But recognize, and also I think as a leader, it's very
Mm-hmm.
important for me. I'm going to work as hard as everybody else,
Mm-hmm.
and I am not going to create fake crises, because that was always when I was.
Quite the opposite.
It's right. I'm not. If I ask you, if I tell you that we need help urgently, it's
Uh-huh.
because it's a real problem. And fostering a team environment where we know we're all in it together, and again, we're communicating, you understand what's going on, and
Mm-hmm.
you're invested in the client. That's
Mm-hmm.
all about how you make somebody want to continue to do this and not drop out of the system, because that's the biggest problem.
Yes, yes. Giving up.
I
Uh,
don't even know if I answered your question, but
yes, you did. You did.
okay.
You surely did. Yes, yes. You're. It's because of your attitude, your approach, and how you say that people should act. And the most important thing is what would happen if they do. They go from here to there, or if they stay there. And this is what mentoring is all about.
Right.
Because taking from your experience and bringing it to them, this is invaluable for young lawyers, young practitioners, because they are this generation. They are anxious about
Right.
many things because they are overwhelmed with information, and not only information, but many yeah, unimportant information, and so many things happening at the same time, and the urge to make decisions and to make the right decision. So all of that is so important, I
Well, and
think.
also I think I don't know how it is in Brazil, but I think the
Mm.
value proposition has changed, because
Mm.
it used to be in the olden, and this is before my time even,
Uh-huh.
if you came in, you worked hard, uh, and you were a good lawyer, you made partner. That changed a
Yes,
long
that's
time ago.
yeah. And for me, this
Right.
is my yes. In my generation, yes. Okay, we are more or less the same. So it used to be like that. It
Yes.
is not anymore.
No. And so we have to recognize that. And so I also think that it's not enough to say we're paying people a lot of money,
Mm-hmm.
which we are,
Mm-hmm.
and that they should now just kind of devote their lives. I think the younger generation doesn't have that same mentality. I think
Nope.
we need to think about, so what are we offering? What kind of experiences, what kind of training? What how do we develop people, and how do we give them an incentive to stay? And if they want to go, we have to be
Yeah.
realistic, and we have to
Yeah.
help them, and recognize that their career path is not going to look the same. They're not going to be laser focused on making partner, and nor should they.
Mm-hmm. Yes. This is an important piece of advice, because sometimes they're so focused on that that they don't produce, then they don't think about what is really important and what really matters at this point. Oh gosh, so good. That's been fascinating, Deborah. uh as we wrap up here, because our time is ticking here, but I would like to extend my deepest gratitude to our esteemed guest, Deborah Dandeneau. Thank you for sharing such valuable insights. I had so much fun. I loved it. I would be here, could be here forever. And you see, this all of that leads me to reflect a bit on the field. uh, Restructuring is not just a process for businesses, it is a profound metaphor for life. Uh, like distressed companies, we all face moments of challenge, uncertainty, and change that demand resilience, creativity, and strategic thinking. So, uh, as legal practitioners, we guide our clients through these storms, but we often forget how much we ourselves embody these principles in our own lives. So I'll leave you with a quote from Albert Einstein, which you may already know: in the middle of difficulty lies opportunity, right? And let's remind, let this quote remind us that challenges, whether in business or in life, they are not the end. They are the beginning of reinvention. So without thoughtful, I'm sorry, with thoughtful planning and determination, we can not only overcome obstacles, but also build a future that's stronger, wiser, and more prosperous. So thank you all for joining us. Deborah,
Thank
thank you
thank you,
again.
Marina. It's been a pleasure. I really have enjoyed chatting with you. Thank you for inviting me to be on this.
Oh, it was an honor. And here's to a year of growth and opportunity for us all.
Here,
And
here.
okay, so take care and keep questioning. See you next time on our next episode of The Global Lawyer. Thank you all. Bye bye.